So the Supreme Court will be considering a case involving the ATF's interpretation of bump stocks as machine guns. So let's talk about this. But real quick before we jump into this video, if you think that the ATF needs to be abolished, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, a case challenging the ATF's interpretation of bump stocks as actual machine guns is now distributed to the Supreme Court for consideration. This case is titled Aposhian v. Garland and has been kind of working its way up to the Supreme Court for a while. Now, some quick background on this whole issue in this case and why this case is important, not just for bump stocks, but other ATF actions which violate our Second Amendment rights as well. So for many years, the ATF had correctly concluded that the NFA and GCA's definition of the term machine gun does not include devices like bump stocks. However, after the incidents in Las Vegas, the ATF, after being ordered by then President Trump, decided to arbitrarily change the regulatory definition of machine gun so that bump stocks would be considered to actually be machine guns. This new rule took effect in March of 2019, and therefore under federal law, owners were required to either destroy the devices or to surrender them to the ATF. This change in definition made possessors of bump stocks subject to a potential punishment of 10 years in prison and or a fine of $250,000 if they failed to either destroy or to surrender the devices. The plaintiff in this case, Mr. Aposhian, purchased a slide-fire bump stock before the ATF's final rule was issued, like many other people did. And then after the ATF changed the interpretation, he filed this lawsuit against them, which is now seeking review from the Supreme Court and has been distributed to the Supreme Court to consider. In response, the Biden administration filed their brief to the Supreme Court, arguing that the ATF has appropriately interpreted the term machine gun to encompass devices like bump stocks. The three main arguments they made in their brief was that the petitioner had failed to show a likelihood of success, that there is no division in authority warranting Supreme Court review, and finally, they argued that the question of Chevron deference does not need review by the Supreme Court. After the Biden administration filed their response, the petitioners filed their reply to that. In their reply, they argued that the Supreme Court should review this case to determine if Chevron can be waived, if Chevron applies to criminal statutes, and they also argued that the case is well suited to address issues of exceptional importance like this. Now, if you're not aware of what Chevron deference refers to, which is kind of an issue in this case, Chevron deference is a term coined after the landmark case, referring to the doctrine of judicial deference given to administrative actions. Generally, for an agency to be given Chevron deference, the agency's interpretation of an ambiguous statute must be rational or reasonable. So when a statute has ambiguous terms, the agency responsible for enforcing that statute may be able to determine what the term was intended to mean, as long as their interpretation of that term is rational or reasonable. In contrast to Chevron deference, there is another rule called the rule of lenity, which indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous law in a way that is most favorable to the people, not the enforcement agency. The interpretation of the definition of a machine gun does in fact involve criminal penalties. Like I mentioned, you can get 10 years in prison for being in illegal possession of a so-called machine gun. So the argument therefore is that in this case, the rule of lenity would direct courts to interpret in the favor of us, the people, not the ATF, and that the rule of lenity should be used instead of Chevron deference. But the whole application, waiver of Chevron deference still is kind of at the core of this case and whether or not it should even be used. So essentially, the US argued that the Supreme Court does not need to review this issue since the ATF properly found bump stocks are machine guns, and since there is no lower court split on the issue as well, they argued that the Supreme Court should not review this case whatsoever. The petitioners in this case argued that the Supreme Court does need to review this issue since there are important criminal implications with the ATF's reinterpretation of the term machine gun, and since this issue of Chevron versus the rule of lenity needs to be determined, especially for lower courts and other issues, not just bump stocks, the application of these two concepts is important for other types of ATF actions. Now, this case has been fully briefed by both of the parties, And also there was some amicus briefs that were filed as well in support and actually against the Supreme Court reviewing this case. So now that it's been fully briefed by the parties, it has been distributed for conference on December 10th. So on December 10th, the Supreme Court will get together and decide whether or not they want to review this issue of the ATF's interpretation of bump stocks as machine guns. So they will decide if they want to actually tackle this or not. If they decide they want to review this case, they will grant what's called certiorari, and then they will set a date for oral arguments. They can also kick the can down the road if they want to and decide to reconsider it at a different conference. So they have set a distributed date for the conference, but sometimes the Supreme Court can't get to those issues on that specific conference date. So they'll kick it down the road for a different conference. That can happen as well. And then of course they could also deny cert, which means they can deny review of this case and just kick it all together, or they could put the case on hold if they want. This case, however, in my opinion, is not a candidate for being put on hold until New York State Rifle and Pistol Association, because New York State Rifle and Pistol Association doesn't really directly bear on this case as much. This is more of an administrative interpretation issue that could be decided outside of the New York State Rifle and Pistol Association guidance, but you never know. The Supreme Court could decide to put this on hold. They put some other cases on hold, some other Second Amendment kind of questions on hold. Those cases were Young and the ANJ-RPC case. Those bared a little bit closer to what is going on with New York State Rifle and Pistol Association, but you can never put it past the Supreme Court. They could put this one on hold as well. But in my opinion, I think what they will do is they will either deny cert or grant cert. So in my opinion, the Supreme Court needs to grant review in this case because the ATF is engaging in reinterpretations, not just with bump stocks, but they're doing it with other things as well, like with the rare breed trigger issue, frames and receivers, and pistol braces as well. So this is not an isolated incident. They are doing it with a lot of things, and all this is resulting in is infringements of our Second Amendment rights, and it's an infringement by an administrative agency who has no authority to interpret things, to make laws, and then enforce those laws. A decision by the Supreme Court in this case would go a long way to striking down all of those other ATF actions. But we will see what the Supreme Court decides to do December 10th. So if you're going to mark a date, December 10th is the date to kind of keep an eye on. Usually the kind of determination will come out the next week, but December 10th, the Supreme Court will get together, they will make their decision. And then the following week, usually we get the Supreme Court order list. You look at the list and it'll tell you essentially kind of what they did. So we will definitely be keeping our eyes on this, and we will see how aggressive the Supreme Court wants to be going forward with these types of Second Amendment issues. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of two-way news. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are directly impacting these videos, impacting this channel, and helping to reach more people than I could have ever thought or could ever do myself. So thank you so much for all the support. If you don't have a comment in mind, just comment down below that you're coming to fuel the algorithm. And also if you're a new subscriber, go ahead and comment down below that you're a new subscriber, and I'll make sure I comment back to you. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is Built by Armed Scholars and stationally maintained by Armed Scholars.